So this is lecture 6 and we are going to look at managing conflict. So in terms of managing conflict, so if you have two employees that are looking at disagreement, and now you escalated the agreement to intensive disagreement between the two parties, what are you going to do? So you want to look at meeting up with the two antagonists, briefly summarizing their points without commenting or interrupting each other. Then short discussion to determine what are the disagreements about and what is the conflicting view. Then interviewing if the employees attack each other. And then ask the two participants to each give 3 or 4 suggestions in how they could resolve the differences. Then as a supervisor, it all talks about how have your actions as a supervisor led to this conflict. So you have to self-reflect at times just to make sure that you're not the cause of the issue. And then all those participants are to discuss and commit. So they need to make the changes to resolve the conflict. They must commit in noticing that others have made changes, no matter how small. Commit to treating each other with dignity and respect. And that it's okay to have reasonable disagreements over issues and plans, but never a personal conflict that affects the workplace. So individuals should resolve conflicts proactively as adults. So you as a supervisor should make sure that it is clear and that you will not choose sides. And then disciplinary actions could lead to dismissal of both parties. And that both parties should be reassured that of their capabilities, of their abilities, and the work that they produce. Do not avoid the conflict and hope that it will go away. It will escalate when stress levels are high or in a new management occurs. And then do not meet separate parties, so then you end up listening to the good side and only the one story, and then you get bias. In the hostile environment, so when the boss or the co-worker whose actions, communication, or behavior makes the job impossible to do. This means that the behavior has altered in, the terms, the conditions, or the reasonable expectations of a comfortable work environment. So in South Africa, constitutional guarantees that the right to equality and also protects all from unfair discrimination. It goes further by making sure that there are actions which makes it possible to advance at disadvantaged groups. So according to the Basic Conditions of Employment Act, no person may be unfairly discriminated or directly or indirectly against an employee in any employment policy or practice. So here we look at the Basic Conditions of Employment Act. I'm not going to go through this. You can read through this if needed, just to get yourself familiarized with the Employment Equity Act. Okay, but just a brief explanation, you'll look at a worker must not work more than 45 hours in any week, 9 hours a day, and 8 hours if the worker works more than 5 days a week. So overtime, if overtime is needed, the worker must agree to it. It's not enforced, and overtime must be paid 1.5 times the worker's normal pay, or by agreement get paid time off. More flexibility of working time can be negotiated if there is a collective agreement with a registered trade union. So you can allow flexi hours. Doesn't mean if you work after 5, it means you overtime. It just means you're working your time back. Meals and break. A worker must have 60 minutes break after 5 hours of work, but a written agreement may lower this to 30 minutes, and you can possibly have a tea. And then a worker must have a daily rest period of after 12 continuous hours of working, the resting period of 36 continuous hours, which unless otherwise agreed must include a Sunday. So Sunday work, anyone that works on a Sunday must be paid 1.5 wages higher, and also public holidays paid same wage as a Sunday, or at some companies get paid double. Night shift workers, because of health issues, that workers working from 6 o'clock to 6 o'clock must get paid extra and work fewer hours for the same amount of money. Transport must be provided, but not necessarily provided by the employer. So workers usually work between 11 o'clock at night and 6 o'clock in the morning must be told of the health and safety risks that are involved. They are entitled for regular checkups, which are paid by the employer, and they must also move to a day shift if the night shift develops into a health problem. All medical examinations must be kept confidential. And jobs and payment. Employers must give new workers information about their job and working conditions in writing. That serves as a contract. This includes a description of any relevant counsel or sexual determinations of a list and a list of any other related documents. So just make sure before you sign any contract with your staff or you signing a new contract, just make sure you read through the documents. You want to make sure that your job description is what it says and what are you going to be doing. You don't want to be paid less or work more with the same hours. Keeping record, so you must keep a record of the worker's name, the time worked, the money paid, and the date of birth for workers under the age of 18. So the employer may work in South African money daily, weekly, fortnightly, or monthly in cash, check, or direct deposit. Each payslip must include the employment's name and address, worker's name and job, period of payment, worker's payment, the amount and purpose of any deduction made from the pay, and amount paid to the actual worker. So proof deduction: an employer may not deduct money from any worker unless the worker agrees in writing or it is by law or permitted in terms of law. So for example, you can't, just because the employee didn't come to work for 3 days, you cannot deduct it. But you can deduct it if you're paying for the employee's medical aid. And then add up the wages. The wages are based on the amount of hours normally worked. Monthly pay is 4 and a third times a weekly wage. Termination of employment. This is important for you guys to just give note of. A worker or employee must give notice to end an employment contract of no less than 1 week if the employment is employed for 6 weeks or less, 2 weeks if more than 6 months but not more than a year, 4 weeks a month if employed for more than a year. Notice must be done in writing from a worker who cannot write, except for workers that cannot write. Workers who stay in employment accommodations must be given 1 month notice of termination of contract, or given alternative accommodation until the contract is terminated. And an employer giving notice does not stop a worker from challenging a dismissal. So you guys might have heard of something called the UIF, where we actually all get paid, and also the labor union, where you can actually complain about your boss if they dismiss you unfairly, and they will fight the case for you to get your maybe a month's salary or 2 months salary, obviously determined on how the dismissal happened. So if you made a mistake and you got 3 warnings already, 3 written warnings, and you get dismissed, even if you go to the union, they're not going to be able to help you. Most of the time, they're not going to get your job back, because the fact that they fired you, meaning that they don't want you, but they do try to at least get 1 or 2 months salary back. Okay, and then employer must pay the worker who dismissed them due to the employment's operational requirements to pay the equal to at least 1 week or several instances pay for the entire year for the continuous service with that employee. Child labor and forced labor. It is against the law to employ a child under the age of 15, and children under the age of 18 may not do dangerous work or work that's meant for adults. It is against the law to force someone to work. Violations of basic conditions of employment. So I'm not going to go into this. You guys can read through this briefly just to make sure that you guys are familiarized with these policies. Okay. Then we're looking at discrimination. Discrimination is based on affirmative actions, characteristic requirements of a particular job, and productivity. And then compulsory discrimination is by law, where you will look at direct or indirect, where unfair candidates gets an advantage or disadvantage based on the criteria that's not job related. So for example, in an interview, make sure your interview questions are job related or based on inherent requirement of the job. Also gain an understanding of the person's ability to perform on the job. Do not discriminate on the following. We are in South Africa, so these are obviously very sensitive topics like race, your gender, your ethnic group, color, sexual orientation, age, and disability. Okay, and then also religion, your beliefs, your political opinion, culture, all of these we can avoid when looking at interview, more become objective. So what you can do is, if you are headhunting someone and you want that person to get the job, you can kind of shape your interview or your requirements or your criteria based on that person's CV, because you have everyone's CV, so that will give them an advantage. And then when you get challenged based on the requirements, you can show them that these were the requirements that we're putting you against, and this was the result. So here we have the trade union. The trade union is an organization of workers that promotes and protects the interest of the members' issues such as wages and working condition. Okay. The principle of the labor union, I'm going to leave that to you guys just to read up a little bit. And also CCMA, you can also look at CCMA. Before that, it's actually the CCMA that was looking at fighting for the party and not the labor law. So yeah. So this here looks at the application and the distribution of referrals. So you have screening and allocations, and then case management, which then gets divided into the departments that looks at the labor law. And then briefly at definitions, you guys must have a look at just to understand and go through. Then professional misconduct. So we all know what professional misconduct is: when we do not treat our patient properly, or we are inefficient, and or we're not equipped enough to treat the patient. So a student or an intern or practitioner shall report impairment in another student, intern, or practitioner to the board if the student is impaired, if the student has impairments, and is informed. Report any unprofessionalism, any illegal acts, and unethical conducts. So now we're looking at lodging a complaint. How do we lodge a complaint to HPCSA when they need to investigate? So what you can do is you can identify the health professional carer against who you want to lodge against. So you want the name, initials, practice address, and practice registration number, the detail, the nature of the complaint, including all relevant dates and facts, as well as supporting documents when available, signed by you, your legal representative, or any other one that's lodging the complaint on your behalf. Include full contact details. So after receiving the complaint, the registrar forwards the complaint to the professional, requests a written explanation. A letter and explanation, if provided, is sent to the professional board for consideration. Should the board consider to take the grounds of the complaint, the professional committee will hold a professional conduct inquiry, during which oral defense or oral evidence is present, often includes independent and expert witnesses. Should the professional conduct inquiry finds the health care professional guilty of misconduct, the committee's decision is final unless either party lodges an appeal. Consequences: if the health professional is found guilty of misconduct, they can caution of warning, a fine, suspension from their practice, removal of her name from the register, so HPCSA in this case, compulsory period of professional service or supervision, payment of the cost of the proceeding. So when looking at the dismissal of health professionals, you must also be aware that they can take your license away, and you have to kind of appeal and get it again. Then the other thing is, if you open your private practice, as we are physios, we are sometimes we go into very awkward positions. For example, a sports player treating the groin area, or your scapula leading to your pec major. So in those areas, and there are people that are out there to get physios, where they charge you for misconduct. So if you are going to start your own private practice, so we're all covered by HPCSA, but we are not covered professionally if we were being taken to court. So you need to be aware that YSASP provides insurance for professionals that covers up to R1 million per patient. That is to cover yourself if you mistreat the patient. For example, if you're treating a hip replacement and you forgot the precautions or the contraindications, and you end up popping the joint, and the family decides to sue you and you don't have insurance. Well, in that case, if you have your own practice, they will sue your practice, which will be you ultimately. Or if you are at the hospital they will sue the hospital, at which the hospital will take action on you. So best way to still buy to get insurance in terms of professional education, professional insurance. And that is lecture 6.